Going live and reading a fairly long and important case called Batson versus Kentucky on page 792 of Criminal Procedure, Trial by Jury and Judicial Impartiality. This is a 1986 case, and Justice Powell delivered the opinion of the court. This case requires us to re-examine that portions of Swain versus Alabama from 1965 concerning the evidentiary burden placed on a criminal defendant who claims that he has been denied equal protection through the use of peremptory challenges to exclude members of his race from the petite jury. Petitioner, a black man, was indicted in Kentucky on charges of second-degree burglary and receipt of stolen goods. On the first day of trial in Jefferson's Circuit Court, the judge conducted voir dire examination on the veneer, excused certain jurors for cause, and permitted the parties to exercise peremptory challenges. The prosecutor uses peremptory challenges to strike all four black persons on the veneer, and a jury composed only of white persons was selected. The defense counsel moved to discharge the jury before it was sworn on the ground that the prosecutor's removal of the black veneer men violated petitioner's rights under the 6th and 14th Amendments of the jury drawn from a cross-section of the community, and under the 14th Amendment to equal protection of the laws. Counsel requested a hearing on his motion. Without expressly ruling on the request for a hearing, the trial judge observed that the parties were entitled to use their peremptory challenges to strike anybody they want to. The judge then denied petitioner's motion, reasoning that the cross-section requirement applies only to the selection of the veneer and not to selection of the petite jury itself. The jury convicted petitioner on both counts. On appeal to the Supreme Court of Kentucky, petitioner pressed, among other things, the argument concerning the prosecutor's use of peremptory challenges, conceding that Swain v. Alabama apparently foreclosed an equal protection claim based solely on the petitioner's conduct in this case. Petitioner urged the court to follow decisions of other states and to hold that such conduct violated his rights under the 6th Amendment and Section 11 of the Kentucky Constitution to a jury drawn from a cross-section of the community. Petitioner also contended that the facts showed that the prosecutor had engaged in a pattern of discriminatory challenges in this case and established an equal protection violation under Swain. The Supreme Court of Kentucky affirmed, and we granted certiorari and now reverse. In Swain v. Alabama, the court recognized that a purposeful or deliberate denial to Negroes on account of race of participation as jurors in the administration of justice violates the Equal Protection Clause. This principle has been consistently and repeatedly reaffirmed in numerous decisions of this court, both preceding and following Swain. We reaffirm the principle today. Accordingly, the component of the jury selection process at issue here, the state's privilege to strike individual jurors through peremptory challenges, is subject to the commands of the Equal Protection Clause. Although a prosecutor ordinarily is entitled to exercise permitted peremptory challenges for any reason at will, as long as that reason is related to his view concerning the outcome of the case to be tried. The Equal Protection Clause forbids a prosecutor to challenge potential jurors solely on account of their race or on the assumption that black jurors as a group will be unable impartially to consider the state's case against a black defendant. Swain required the court to decide, among other issues, whether a black defendant was denied equal protection by the state's exercise of peremptory challenges to exclude members of his race from the petite jury. The record in Swain showed that the prosecutor had used the state's peremptory challenges to strike the 6 black persons included in the petite jury veneer, while rejecting the defendant's claim for failure to prove purposeful discrimination. The court nonetheless indicated that the Equal Protection Clause placed some limits on the state's exercise of peremptory challenges. The court sought to accommodate the prosecutor's historical privilege of peremptory challenge free of judicial control and the constitutional prohibition on exclusion of persons from petite service on account of race. While the Constitution does not confer a right to peremptory challenges, whose challenges traditionally have been viewed as one means of assuring selection of qualified and unbiased jury, to preserve the peremptory nature of the prosecutor's challenge, the court in Swain declined to scrutinize his actions on a particular case by relying on presumption that he properly exercised the state's challenges. The court went on to observe, however, that the state may not exercise its challenges in contravention of the Equal Protection Clause. It is impermissible for a prosecutor to use its challenges to exclude blacks from the jury for reasons wholly unrelated to the outcome of a particular case in trial, or to deny blacks the same right, an opportunity to participate in the administration of justice enjoyed by the white population. Accordingly, a black defendant could make out a prima facie case of purposeful discrimination on proof that the peremptory challenge system is being perverted in that manner. For example, an inference of purposeful discrimination will be raised on evidence that a prosecutor, in case after case, whatever the circumstances, whatever the crime, and whoever the defendant or victim may be, is responsible for the removal of Negroes who have been selected as qualified jurors by the jury commissioners and who have survived challenges for cause, with the result that no Negroes ever serve on petite juries. So this is, I guess, an example. Evidence offered by the defendant in Swain did not meet that standard. While the defendant showed that prosecutors on the jurisdiction had exercised their strikes to exclude blacks from the jury, he offered no proof of the circumstances under which prosecutors were responsible for striking black jurors beyond the facts of his own case. A number of lower courts following the teaching of Swain reasoned the proof of repeated striking of blacks over a number of cases was necessary to establish a violation of the Equal Protection Clause. Since this interpretation of Swain has placed on defendants a crippling burden of proof, prosecutors' peremptory challenges are now largely immune from constitutional scrutiny. For reasons that follow, we reject this evidentiary formulation as inconsistent with standards that have developed. Sorry. Prosecutors' peremptory challenges are now largely immune from constitutional scrutiny. For reasons that follow, we reject this evidentiary formulation as inconsistent with standards that have been developed since Swain for assessing a prima facie case under the Equal Protection Clause. Since the decision in Swain, the courts recognize that a defendant may make a prima facie showing of purposeful racial discrimination in selection of the veneer by relying solely on the facts concerning its selection in his case. So this was the burden of proof apparently after Swain. And I think it's been reduced. Relying solely on the facts concerning its selection in his case. These decisions are in accordance with the proposition that a consistent pattern of official racial discrimination is not a necessary predicate to the violation of the Equal Protection Clause. So, new burden. A single invidiously discriminatory governmental act is not immunized by the absence of such discrimination in the making of other comparable decisions. For evidentiary requirements to dictate that several must suffer discrimination before one could object would be inconsistent with the promise of equal protection to all. I wish I knew where that quote came from. There's some There's at least Powers versus Ohio here in the case, or in the notes, the footnotes. Holland versus Illinois. JEB versus Alabama ex relatium. Georgia versus McCollum. So I don't know where that quote comes from, but I like it. The standards for assessing a prima facie case in the context of discriminatory selection of the veneer have been fully articulated since Swain. These principles support our conclusion that a defendant may establish a prima facie case of purposeful discrimination in selection of the petite jury solely on evidence concerning the prosecutor's exercise of peremptory challenges at the defendant's trial. To establish such a case, the defendant first must show that he is a member of the cognizable racial group. So that's first. And second, that the prosecutor has exercised peremptory challenges to remove from the veneer members of the defendant's race. Actually, second, it starts now. The defendant is entitled to rely on the fact as to which there can be no dispute that peremptory challenges constitute a jury selection practice that permits those to discriminate who are of a mind to discriminate. And finally, the defendant must show that these facts and any other relevant circumstances raise an inference that the prosecutor used that practice to exclude the veneer men from the petite jury on account of their race. This combination of factors in the impaneling of the petite jury as a selection of the veneer raises the necessary inference of possible purposeful discrimination. So, in the analysis, you have to write necessary inference of purposeful discrimination, like 1, 2, and 3. And that's all on page 796. So, in deciding whether the defendant has made the requisite showing, the trial court should consider all relevant circumstances. For example, a pattern of strikes against black jurors included in the particular veneer might give rise to an inference of discrimination. Similarly, the prosecutor's questions and statements, including voir dire examination, and in exercising his challenges may support or refute an inference of discriminating purpose. These examples are merely illustrative. We have confidence that trial judges experienced in supervising voir dire will be able to decide if the circumstances concerning the prosecutor's use of peremptory challenges creates a prima facie case of discrimination against black jurors. Once the defendant makes a prima facie showing, the burden shifts to the state to come forward with a neutral explanation for challenging black jurors. And there's a burden shift to state for explanation. Neutral explanation. So, though this requirement imposes a limitation in some cases on the full peremptory character of the historical challenge, we emphasize that the prosecutor's explanation need not rise to the level justifying the exercise of a challenge for cause, but the prosecutor may not rebut the defendant's prima facie case of discrimination by stating merely that he challenged jurors of the defendant's race on the assumption or his intuitive judgment that they would be partial to the defendant because they shared the same race, because they shared race. Just as the Equal Protection Clause forbids the states to exclude black persons from the veneer on the assumption that blacks as a group are unqualified to serve as jurors, so it forbids the states to strike black veneer men on the assumption that they will be biased in a particular case because the defendant is black. The core guarantee of equal protection ensuring citizens that their state will not discriminate on account of race would be meaningless were we to approve the exclusion of jurors on the basis of such assumptions, which arise solely from the juror's race. Nor may the prosecutor but the defendant's case merely by denying that he had a discriminatory motive or affirming his good faith in individual selections. If these general assertions were accepted as rebutting the defendant's prima facie case, the Equal Protection Clause would be in vain an illusory requirement. The prosecution, therefore, must articulate a neutral explanation related to the particular case to be tried. Trial court will then have the duty to determine if the defendant has established purposeful discrimination. The state contends that our holding will eviscerate the fair trial values served by the peremptory challenge, conceding that the Constitution does not guarantee a right to a peremptory challenge, and that Swain did state that their use ultimately is subject to the strictures of equal protection. The state argues that the privilege of unfettered exercise of the challenge is of vital importance to the criminal justice system. While we recognize, of course, that the peremptory challenge occupies an important position in our trial procedures, we do not agree that our decision today will undermine the contribution the challenge generally makes to the administration of justice. I don't even understand those counter arguments. I understand the response. The reality of practice amply reflected in many state and federal court opinions shows that the challenge may be, and unfortunately at times has been used to discriminate against Black jurors. By requiring trial courts to be sensitive to the racially discriminatory use of peremptory challenges, our decision enforces the mandate of equal protection and furthers the end of justice. The ends of justice. So, Hernandez versus New York, Miller L. versus Drecke, Snyder versus Louisiana, Hargett versus Ellum. Lots of cases in the footnotes. In view of the heterogeneous population of our nation, public respect for our criminal justice system and the rule of law will be strengthened if we ensure that no citizen be disqualified from jury service because of his race. Nor are we persuaded by the state's suggestion that our holding will create serious administrative difficulties. In those states applying a version of the evidentiary standard we recognize today, courts have not experienced serious administrative burdens, and the peremptory challenge system has survived. We decline, however, to formulate particular procedures to be followed upon a defendant's timely objection to a prosecutor's challenges. In this case, petitioner made a timely objection to the prosecutor's removal of all Black persons on the veneer. Because the trial court flatly rejected the objection without requiring the prosecutor to give an explanation for his actions, our precedents require the petitioner's conviction be reversed. So, Justice Marshall concurs. Justice Berger joined in, Justice Rehnquist dissenting, and checking about how long it might be to read dissenting opinions. Right now we're at about 2.5 pages. Then you have Rehnquist, with whom the Chief Justice joins dissenting. So there's 4 people dissenting, 4 justices dissenting over 4 pages. Also would like to read the footnotes. So let's try to blurt those out quickly before the dissent. In this court, petitioners argued that the prosecutor's conduct violated his rights under the 6th and 14th Amendments to an impartial jury and to a jury drawn from a cross-section of the community. Petitioner has framed his argument in the terms of an apparent effort to avoid inviting the court directly to reconsider one of its own precedents. On the other hand, the state has insisted that petitioner is claiming a denial of equal protection and that we must reconsider Swain to find a constitutional violation on this record. We agree with the state that resolution of petitioner's claim probably turns on application of equal protection principles and express no view on the merits of any of petitioner's 6th Amendment arguments. Editor's note, later in Holland v. Illinois, 1990, the court rejected 5-4 the thesis that the prosecutor's use of peremptory challenges to eliminate a distinctive group in the community deprives the defendant of a 6th Amendment right to the fair possibility of a representative jury. All statements in our prior cases have alluded to such a fair possibility requirement. Satisfying it has not been held to require anything beyond the inclusion of all cognizable groups in the veneer and the use of a jury ordering at least 6 persons. Editor's note on standing, see Powers versus Ohio, described super in the editor's note A, where the court concluded that a peremptory challenge of a potential juror on the basis of race violates that juror's equal protection rights, and the defendant has standing to raise the juror's claim. Soon afterward, the court extended Batson to bar peremptory challenges based on gender, overturning a paternity case in which the state's attorney had used the challenges to exclude men. The court reasoned all persons have the right not to be excluded summarily because of discriminatory and stereotypical presumptions that reflect and reinforce patterns of historical discrimination. It denigrates the dignity of the excluded juror, and for a woman, reinvokes the history of exclusion from political participation. And that's a reading from J.E.B. versus Alabama Ex Rel. TP in 1994. We express no views on whether the Constitution imposes any limit on the exercise of peremptory challenges by defense counsel. Editor's note, later in Georgia versus McCollum, 1992, the court held Batson was applicable where the prosecutor sought to prevent white defendants charged with assaulting blacks from striking black prospective jurors because of their race. The court reasoned that Romanet 1, a criminal defendant's exercise peremptory challenges in a racially discriminatory manner inflicts the harms addressed by Batson, denial of prospective jurors' right to serve as jurors, and loss of public confidence in the fairness of jury verdicts. Romanet 2, such exercise of peremptories constitutes state action as defendant in exercising peremptories is performing a traditional governmental function. And Romanet 3, the state is standing to challenge the defendant's discriminatory use of peremptory challenges as its own judicial process is undermined thereby, and there are significant barriers to the excluded jurors themselves obtaining relief. And Romanet 4, the interest served by Batson need not give way to the rights of the criminal defendant, as the defendant's rights to a fair trial, counsel, and an impartial jury do not include the right to discriminate against a group of citizens based upon their race. Thomas J. Concurring found difficult a statement in the NAACP's brief stating that whether white defendants can use peremptory challenges to purge minority jurors presents quite different issues from whether minority defendant can strike majority group jurors. In Swain, the court reviewed the very old credentials of the peremptory challenge system and noted the long and widely held belief that peremptory challenges a necessary part of trial by jury. The lower courts have noted the practical difficulties of proving that the state systematically has exercised peremptory challenges to exclude blacks from the jury on account of race. The defendant would have to investigate over a number of cases the race of persons tried in the particular jurisdiction, the racial composition of the veneer and petite jury, and the manner in which both parties exercised their peremptory challenges. In jurisdictions where court records do not reflect the jury race and where voir dire proceedings are not transcribed, the burden would be insurmountable. But in Powers versus Ohio, 1901, the court held 7-2 that a white defendant may object to the prosecution's peremptory challenges of black veneer persons. The majority reason that such challenges are based upon race violate the veneer person's right to an equal protection under the 14th Amendment, as to which a criminal defendant has standing to object because 3 criteria for recognizing third-party standing are present. The defendant has suffered an injury in fact by such peremptory challenge adequate to give him or her a sufficiently concrete interest in the outcome of the issue in dispute for the overt wrong, often apparent to the entire jury panel, cast doubt over the obligation of the parties, the jury, and indeed the court to adhere to the law throughout the trial of the cause. The defendant has a close relation to the third party, excluded veneer persons, as he or she will be motivated effective advocate for the excluded veneer person's rights, even given that discrimination in the jury selection process may lead to the reversal of conviction. There exists some hindrance to a third party's ability to protect his or her own interests for potential jurors, have no opportunity to be heard at the time of their exclusion, cannot easily obtain declaratory or injunctive relief later, given the need to show a likely reoccurrence of their own exclusion based on race, and are unlikely to undertake an action for damages because of the small financial stake involved and the economic burdens of the injunction. Litigation, As the court later explained in Perkett v. LM, 1995, at the second stage, it is not necessary that the prosecutor's explanation also be at least minimally persuasive, for such a requirement would violate the principle that the ultimate burden of persuasion regarding the racial motivation rests with and never shifts from the opponent of the strike. But at the third stage, when the trial court must decide if the opponent did carry this burden, implausible or fantastic justifications may, and probably will be found to be pretext for purposeful discrimination. See also Hernandez case in Note C and Frapp. So next, in Hernandez v. New York, Justice Kennedy, the four members of the court concluded the prosecutor here, on a race-neutral basis for these peremptory strikes, as explained by the prosecutor, the challenges rested neither on the intention to exclude Latino or bilingual jurors, nor on stereotypical assumptions about Latinos or bilinguals. The prosecutor's articulated basis for these challenges divided potential jurors into two classes: those whose conduct during voir dire would persuade him that they might have difficulty in accepting the translator's rendition of Spanish language testimony, and those potential jurors who gave no such reason for doubt. Each jury would include both Latinos and non-Latinos, while the prosecutor's criterion might well result in a disproportionate removal of prospective Latino jurors. That disproportionate impact does not turn the prosecutor's actions into a per se violation of the Equal Protection Clause. However, if a prosecutor articulates a basis for a peremptory challenge that results in a disproportionate exclusion of members of a certain race, the trial judge may consider the fact as evidence that the prosecutor's stated reason constitutes a pretext for racial discrimination. The court then concluded the state's finding that no discriminatory intent should stand because not clearly erroneous. So that's the Hernandez case. In Miller, actually, two concurring members of the court emphasized that if the trial court believes the prosecutor's non-racial justification and that finding is not clearly erroneous, that is the end of the matter, meaning disproportionate effect is then irrelevant. So in Miller L. versus Dretke, 2005 now, the court concluded if a prosecutor's proffered reason for striking a black panelist applies just as well as to an otherwise non-black who is permitted to serve, that is evidence tending to prove purposeful discrimination to be considered at Batson's third step. In Miller L., prosecutor's race-neutral reasons for excluding black jurors were basically applicable to white jurors who were not challenged, I should say. So, this finding led the court to conclude that Texas prosecutors who had acted with intentional discrimination, at least when it was considered together with other evidence, specifically that one, a prosecutor had requested a shuffle in order of prospective jurors, which lowered the likelihood the blacks would reach the jury box. Two, the prosecutor questioned questioning of black and white prospective jurors differed in ways that made it easier to challenge blacks for cause. Three, the prosecutor had access to an old prosecutor's manual advocating the exclusion of blacks from juries. And four, the prosecutor had noticed the race of each prospective juror on the materials used during jury selection. Concluding that the trial court had committed clear error in finding that the prosecution did not intend to include a black juror on the basis of race, the court invalidated a conviction in Snyder v. Louisiana in 2008. The court noted the record showing that while the excluded juror expressed concern about missing school, two white jurors, at least as concerned about their conflicting obligations, were allowed to serve. But the trial judge did not credit the prosecutor's statement that was excluded juror was nervous. While we respect the views expressed in Justice Marshall's concurring opinion concerning prosecutorial and judicial enforcement of our holding today, we do not share that standard. We adopt under the federal constitution that is designed to ensure the state does not use peremptory challenges to strike any black juror because of his race. We have no reason to believe that prosecutors will not fulfill their duty to exercise their challenges only for legitimate purposes. Prosecutors will not fulfill their duties to exercise their challenges only for legitimate purposes. Certainly, this court may assume the trial judges and supervising voir dire in light of our decision today will be alerted to identify a prima facie case of purposeful discrimination. Nor do we think that this historical trial practice, which long has served the selection of an impartial jury, should be abolished because of an apprehension that prosecutors and trial judges will not perform conscientiously their respective duties under the Constitution. In light of a variety of jury selection practices followed in our state and the federal trial courts, we make no attempt to instruct these courts how best to implement our holding today. For the same reason, we express no view on whether it is more appropriate in a particular case upon finding discrimination against black jurors for the trial court to discharge a veneer and select a new jury from a panel not previously associated with the case, or to disallow the discriminatory challenges and resume selection with the improperly challenged jurors reinstated on the veneer. I was wondering how that works. So, let me just check that's the last. I hope that's the last footnote. It looks like possibly that's the last footnote. Well, there's one on the later page of the dissenting opinion. So, Marshall concurs. I wholeheartedly concur with the court's conclusion that the use of peremptory challenge to remove blacks from juries on the basis of their race violates the Equal Protection Clause. Would go further, however, in fashioning a remedy to adequate to eliminate that discrimination, merely allowing defendants the opportunity to challenge the racially discriminatory use of peremptory challenges in individual cases will not end the illegitimate use of peremptory challenge. Evidentiary analysis under that set out by the court has been adopted as a matter of state law in states including Massachusetts and California. Cases from those jurisdictions illustrate the limitations of the approach. First, the defendants cannot attack the discriminatory use of peremptory challenges at all unless the challenge is so flagrant as to establish a prima facie case. This means in those states where that where only one or two black jurors survived challenges for cause, a prosecutor need have no compunction about striking them from the jury because of their race. Prosecutors are left free to discriminate against blacks, and jury selection provided that they hold discrimination to an acceptable level. I've never heard the word before called compunction. COMPUNCTIO. Second, when the defendant can establish a prima facie case, trial courts face a difficult burden of assessing prosecutors' motives. Any prosecutor can easily assert facially neutral reasons. How is the court to treat a prosecutor's statement? To second guess those reasons. How is the court to treat a prosecutor's statement? And he struck a juror because the juror had or seemed uncommunicative or never cracked a smile and therefore did not possess the sensitivity necessary to realistically look at the issues and decide facts of the case. Hard. If such easily generated explanations are sufficient to discharge the prosecutor's obligation and to satisfy let's just say justify his strikes on non-racial grounds, then the protection directed by the court today may be illusory. Nor is outright prevarication by prosecutors the only danger here. It is possible that an attorney may lie to himself in an effort to convince himself that the motives were legal. So it corrupts lawyers. This also corrupts the very lawyers. Okay, anyway, it is even possible that an attorney may lie to himself in an effort to convince himself that his motives are legal. Alright. A prosecutor's own conscious or unconscious racism may lead him to easily to the conclusion that a prospective black juror is sullen or distant, a characterization that would not have come to his mind if a white juror had acted identically. A judge's own conscious or unconscious racism may lead him to accept such an explanation as well supported. The inherent potential of peremptory challenges to distort the jury process by permitting the exclusion of jurors on racial grounds should ideally lead the court to ban them entirely from the criminal justice system. Some authors have suggested that the courts should ban prospective, but should zealously guard the defendant's peremptories as essential to the fairness of the trial by jury and one of the most important of the rights secured to the accused. I would not find that an acceptable solution. Our criminal justice system requires not only freedom from the bias against the accused, but also from the prejudice against his prosecution. Between him and the state, the scales are to be evenly held. We can maintain that balance not by permitting both prosecutor and defendant to engage in racial discrimination in jury selection, but by banning the use of peremptory challenges by prosecutors and by allowing the states to eliminate the defendant's peremptory as well. Chief Justice Berger, joined by Justice Rehnquist, dissenting. The court acknowledges, albeit in a footnote, that the very old credentials of the peremptory challenge and the widely held belief that peremptory challenge is a necessary part of trial by jury. But proper resolution of the case requires more than a nodding reference to the purpose of the challenge. The court's opinion, in addition to ignoring the teachings of history, also contrasts with Swain in its failure to even discuss the rationale of the peremptory challenge. Swain observed, the function of the challenge is not only to eliminate extremes of impartiality on both sides, but to assure that the jurors before whom they try the case will decide on the basis of evidence placed for them, and not otherwise. In this way, the peremptory satisfies the rule that to perform its high function in the best way, justice must satisfy the appearance of justice. Okay, whatever. Permitting unexplained peremptories has long been regarded as a means to strengthen our jury system in other ways as well. One commentator has recognized the peremptory made without giving any reason avoids trafficking in the court of truth in the most common stereotypes. Common human experience, common sense, psychosociological studies, and public opinion polls tells us that it's likely that certain classes of people statistically have predispositions that would make them inappropriate jurors for particular kinds of cases. But to allow this knowledge to be expressed in the evaluative terms necessary for challenges to cause would undercut our desire for a society in which all people are judged as individuals and in which each is held reasonable and open to compromise. For example, although experience reveals that black males as a class can be biased against young alienated blacks who have not tried to join the middle class, to enunciate this in the concrete expression required of a challenge for cause is societally divisive. Instead, we have evolved in the peremptory challenge, a system that allows the covert expression of what we dare not say but know is more often than not. For reasons such as these, the court concluded in Swain that the peremptory challenge is one of the most important of the rights in our justice system. For close to a century, then, it has been settled that the denial or impairment of the right is reversible error without a showing of prejudice. The court also invokes general equal protection principles in support of its holding, but peremptory challenges are often launched of necessity for reasons normally thought irrelevant to legal proceedings or official action, namely the race, religion, and nationality, occupation, or affiliations of people summoned for jury duty. Swain. Moreover, in making peremptory challenges, both the prosecutor and defense attorney necessarily act on only limited information or hunch. The process cannot be indicted on the sole basis that such decisions are made on the basis of assumption or intuitive judgment. As a result, unadulterated equal protection analysis is simply inapplicable to peremptory challenge exercise in any particular case. A clause that requires a minimum rationality in government action has no application to an arbitrary and capricious right. A constitutional principle that may invalidate state action on the basis of stereotypic notions does not explain the breadth of a procedure exercised on the sudden impressions and unaccountable prejudices we are apt to conceive upon the bare looks and gestures of another. That the court is not applying conventional equal protection analysis is shown by its limitation of its new rule to allegations of impermissible challenge on the basis of race. The court's opinion clearly contains such a limitation, but if conventional equal protection is on the basis of not only race, but also sex, age, religious or political affiliation, mental capacity, number of children, living arrangements, unemployment, and other in a particular industry or profession. In short, it is quite probable that every peremptory challenge could be objected to on the basis that because it excluded a veneer man who had some characteristic not shared by the remaining members of the veneer. It constituted classification subject to equal protection scrutiny, compounding the difficulties under conventional equal protection principles. Some uses of peremptories would be reviewed under strict scrutiny and sustained only if suitably tailored to serve a compelling state interest. Others would be reviewed to determine if they were substantially related to a sufficiently important government interest, and still others would be reviewed to determine whether they were a rational means to serve a legitimate end. The court never applies this conventional equal protection framework to the claims at hand, perhaps to avoid acknowledging that the state interest involved here has historically been regarded by this court as substantial, if not compelling. The court also purports to express no views on whether the Constitution imposes any limit on the exercise of peremptory challenges by defense counsel, but the clear and inescapable import of this novel holding will inevitably be to limit the use of this valuable tool to both prosecutors and defense attorneys alike. Once the court has held that prosecutors are limited in their use of peremptory challenges, we would rationally hold that defendants are not, ? And this takes you to footnote 6. Every jurisdiction which has spoken to the matter prohibited prosecution case-specific peremptory challenges on the basis of cognizance. Footnote 4 from earlier, while all these distinctions might support a claim under conventional equal protection principles, a defendant would also have to establish standing to raise them before obtaining any relief. Alright, so confronted with the dilemma it created, the court today attempts to create a middle ground. To refute a prima facie case, the court requires a neutral explanation for the challenge, but is at pains to emphasize that the explanation need not rise to the level justifying exercise of a challenge for cause. I am at a loss to discern the governing principles here. A clear and reasonably specific explanation of legitimate reasons for exercising the challenge will be difficult to distinguish from a challenge for cause. Anything short of a challenge for cause may well be seen as an arbitrary and capricious challenge, to use Blackstone's characterization of the peremptory. Apparently, the court envisions permissible challenges short of a challenge for cause that are just a little bit arbitrary, but not too much. While our trial judges are experienced in supervising voir dire, they have no experience in administering roles like this. An example will quickly demonstrate how today's holding, while purporting to further the ends of justice, will not have that effect. Assume an Asian defendant on trial for the capital murder of a white victim. Ask prospective jury members, most of whom are white, whether they harbor racial prejudice against Asians. The basis for such a question is to flush out a new juror who believes that Asians are violent, prone, or morally inferior. Assume further that all white jurors deny harboring racial prejudice, but that the defendant on trial for his life remains unconvinced by these protestations. Instead, he continues to harbor a hunch, an assumption, or intuitive judgment that these white jurors will be prejudiced against him, presumably based in part on race. The time-honored rule before today was the peremptory challenge could be exercised on such a basis. The effect of the court's decision, however, will be to force the defendant to come forward and articulate a neutral explanation for his peremptory challenge, a burden he probably cannot meet. This example demonstrates that today's holding will produce juries that the parties do not believe are truly impartial. This will surely do more than disconcert litigants. It will diminish confidence in the jury system. Today, we mark the return of racial differentiation as the court accepts the positive evil for a perceived one. Prosecutors and defense attorneys alike will build records in support of their claims that peremptory challenge their racial background and national origin for the record, despite the fact that such questions may be offensive to some jurors and thus are not ordinarily asked on voir dire. This process is sure to tax even the most capable counsel and judges, since determining whether a prima facie case has been established will require continued monitoring and recording of the group composition of the panel of press and perspective. Justice Rehnquist, with whom Chief Justice joins dissenting, I cannot subscribe to the court's unprecedented use of the Equal Protection Clause to restrict the historic scope of the peremptory challenge, which has been described as a necessary part of trial by jury. In my view, there is simply nothing unequal about the state using its peremptory challenges to strike blacks from the jury in cases involving black defendants, so long as such challenges are also used to exclude whites in cases involving white defendants, Hispanics in cases involving Hispanic defendants, Asians in cases involving Asian defendants, and so on. This case-specific use of peremptory challenges by state does not single out blacks or members of any other race, for that matter, for discriminatory treatment. Such use of peremptories is at least based upon seat of the pants instincts, which are undoubtedly crudely stereotypical and may in many cases be hopelessly mistaken. But as long as they are applied across the board to jurors of all races and nationalities, I do not see, and the court most certainly does not explain, how their use violates the Equal Protection Clause. Nor does such use of peremptory challenge by the state infringe upon any other constitutional interest. The court does not suggest that exclusion of blacks from the jury through the state use of peremptory challenges results in a violation of either a fair cross-section or impartiality component of the Sixth Amendment, and because the case-specific use of peremptory challenges by the state does not deny blacks the right to serve as jurors in cases involving non-black defendants, it harms neither the excluded jurors nor the remainder of the community. The use of group affiliation such as age, race, or occupation as a proxy for potential juror impartiality based on the assumption or belief that members of one group are more likely to favor defendants who belong in the same group has long been accepted as a legitimate basis for the state's exercise of peremptory challenges. Indeed, given the need for reasonable limitations on the time devoted to voir dire, the use of such proxies by both the state and the defendant may be extremely useful in eliminating from the jury persons who may be biased in one way or another. So that's the end of Batson.